A Section 8 notice. What is it, and why would a landlord want to serve one? A Section 8 notice is a notice under the Housing Act 1988. It now only applies to England, and it also only applies to assured tenancies and assured short-hold tenancies. It's the first step a landlord takes to seeking for possession of their property. It gives a tenant legal notice that they should vacate the let premises by a certain date for a particular reason. These reasons are known as grounds for possession, and there are various grounds on which a landlord can serve a Section 8 notice, from rent arrears, delayed payments of rent, to antisocial behaviour and more. These are all grounds on which the law says a landlord can terminate a tenancy. Some grounds are mandatory, which mean if the court is satisfied the ground is made out, the court must make a possession order. Some of the grounds are discretionary grounds, which mean that even if you prove that that ground is made out and you've proved the allegations against the tenant, the court may or may not make a possession order. In this video, we'll be focusing on how to show you to draft your own Section 8 notice based on unpaid rent and how to correctly serve it on your tenant. It's very important to ensure you're using the up-to-date version of this form, which is usually available from the government website. You can also download this document from our website at landlordadvice.co.uk. So we'll show you the form and we'll get started.
So here we have the Section 8 notice. This is downloadable from the government website. It's referred to as Form 3. It's also downloadable from our website and many other platforms. It's very important that you check you're using the up-to-date version of this form. Failure to use the correct version of the form could result in a defective notice being served on the tenant. Now, although there are some technical points of law that can allow a landlord in certain circumstances to successfully rely on a defective notice, those arguments can be costly, they do come with risks, and they often do result in delays with the eviction procedure. It's of course far better to make sure you get this step right. So we'll go to paragraph 1 of this form, which requires you to insert the name of the tenant. In the case of a joint tenancy, you'd be stating the names of all the joint tenants. So in this case, we'll be stating that the tenant's name is Mr. Rishi Sunak. Paragraph 2 is where you'll be stating the full address of the let property. In this case, we'll be stating that that's 10 Downing Street in London. Paragraph 3 is where you'll state the grounds on which the notice is being served, as set out in the legislation, which is the Housing Act 1988. You'll also have to state the full text of those grounds as per the legislation. This notice is being served based on unpaid rent, which is 2 months or more worth of rent arrears. So we've got grounds 8, 10 and 11 in this case for rent arrears. So we've got paragraph 3, which now states your landlord or licensor intends to seek possession on grounds 8, 10 and 11 in Schedule 2 to the Housing Act 1988 as amended, which reads, give the full text as set out in Schedule 2 of the Housing Act 1988 of each ground which is being relied on. If you download this notice from our website, you will get an additional document with it, which has all the grounds on which this notice is being served or can be served, and you'll be able to simply copy the applicable grounds in your particular case from that document into your notice here. So I've got my additional document here, and this is where I'll be copying and pasting the text of those grounds from the Act into my notice here. So I've got ground 3, confirmation of the grounds I'm relying on, and I've now got the full text of what those grounds state in the legislation as required. And that's grounds 8, 10 and 11 in this case for unpaid rent. Paragraph 4 is where you'll give an explanation as to why each ground is being relied on. In this case, I'm relying on grounds 8, 10 and 11 for the same reason, in that the tenants failed to pay the rent in accordance with the terms of the tenancy. Now, if of course you are serving this notice for different reasons, it would be appropriate to set out each particular ground and give a separate explanation as to why each ground is actually being relied on. To make things a little easier, I've got some text that I've already drafted that I'll insert here, which is my explanation as to why I'm serving this notice on grounds 8, 10 and 11, and that explanation reads: the current rent is £1,000 per month, payable in advance of each month. The tenant has failed to pay the rent as and when it falls due under the terms of the tenancy agreement. The landlord has made various attempts to communicate with the tenant, to no avail. The rent is now outstanding in the sum of £3,000. See rent statement attached. Now, it's not a requirement to attach a rent statement, but it is recommended as it can help ensure the figures that you're referring to are correct. Now, here I've put a date of the 22nd of February in paragraph 5. Paragraph 5 is where you'll state the notice period. This is the date by which the tenant must comply with the notice. It's also the date after which the landlord can apply to the court to seek a possession order based on the grounds stated in this notice. Now, there are different notice periods for different grounds. In the case of rent arrears, the minimum notice the tenant must be given is 14 days notice. Now, this is the part of the form that a lot of landlords often get wrong when they're drafting their own notices. The 14 days notice given must take into account how you're serving the notice on the tenant. For instance, if you're serving the notice personally to the let property the same day that you've drafted the notice, the 14 days would start from that date, and you could easily calculate the 14 days. In this instance, I'll be stating that I'm serving the notice by first class post and a second copy, for example, by first class recorded delivery on the 6th of February 2023. So it'll be going to the post office on this date. I need to allow at least 2 working days before that notice actually reaches the tenant. So I'm calculating 14 days from the date this notice reaches the let property, and 14 days from that lands on the 22nd of February, which is how I've arrived at this date here. So I'm confident that this notice will give the tenant at least 14 days notice. There is of course no harm in giving a few extra days to avoid any doubt. Paragraph 6 doesn't require any text to be added or any amendments to be made. This is simply information for the tenant. And we're now at the final paragraph of the notice, which is paragraph 7. This is where the notice will be signed by the landlord or somebody acting on the landlord's behalf. The name and address and contact number of the landlord or the person or company serving the notice for the landlord will be inserted here. So as you can see, I've already inserted Landlord Advice UK as the person authorised to serve this notice on the landlord's behalf. We've got our address here, we've got our contact number, and the notice of course needs to be dated, which I have done here. You then got this capacity section in which you'll simply tick the capacity in which you've drafted and served this notice. It's either the landlord, one of the joint landlords, or the landlord's agent, which is somebody acting on the landlord's behalf. And that is the end of a Section 8 notice being drafted based on unpaid rent on grounds 8, 10 and 11. It's important to note that this is for example purposes only. There are different grounds for different reasons, and it's very wise to seek legal advice. If you are drafting your own notice, you can send that to our team, and our team will skim over that free of charge for you and give you any recommendations as to whether anything should be amended, and also more importantly advise you on whether you're using the correct version of the form, and if you're giving the correct notice period for the grounds that you're relying on. If you do download this notice from our website, again, that will come with an additional document with a full text of all of the grounds for possession as set out in the legislation. This will allow you to quite easily copy and paste the appropriate grounds into your notice.